information on, so you can view training materials and recordings right from our website. You can, hopefully by late next week, you'll see it. If you want to refer this to anyone, you'll be able to see refer them to our website. You can see a recording of this training, previous trainings, and the PowerPoint that we'll be using. Okay, so now I'm going to go back to, sharing our PowerPoint. Okay. I think there was just maybe because I had the chat box open, that might have been the problem why people were having a hard time seeing the web screen. So I will close that out. So if you're asking me questions, I may not see them until the end, only because I don't want to block people's view if that's occurring with the PowerPoint as well. So there's just what if you did have a hard time seeing it, that is what our website looks like. And I just went over how to find some important information there. The original Freedom of Information Law was enacted in 1974, but was pretty limited in scope. You only had access to 9 categories of records. And if you didn't see what you were looking for on the list of records that was contained in the statute, you were sort of out of luck. Well, no one really liked that version of the statute, so in 1978, the original version was repealed and replaced with what is essentially the current model of what we have now. Of course, it's not exactly the same, but the model is the same, and it's based on a presumption of access. And so what that means is when you either are making a Freedom of Information Law request, or if you're a government employee that's receiving a Freedom of Information Law request, you start with the assumption that all government records are subject to FOIL disclosure. And then you review the content of the records to determine whether the record or any portion of the record fits into one of the permissible grounds for denial. Who is covered by FOIL? FOIL governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. So in short, any type of government entity and agency that you can think of is likely going to be subject to the requirements of the Freedom of Information Law, is going to be considered an agency under the Freedom of Information Law, except the judiciary or the state legislature. So we start with villages, towns, cities, counties, libraries, fire districts, water districts, going, up the levels. And then, of course, at the state agency, every state executive agency, the Attorney General's office, the Comptroller's office, all of those government entities are agencies under the Freedom of Information Law and are required to comply with the Freedom of Information Law. Access to the court records, the judiciary, is not through the Freedom of Information Law. The courts are exempt from having to comply with the Freedom of Information Law. And that doesn't mean that many court records aren't public. It just means that there are other statutes that govern access to those records. It's through the judiciary law, and that's not really our area of expertise. If you ever have questions about accessing court records, the best place to start is with the appropriate court clerk, and hopefully they can walk you through the process. If you need to bump it up a level, I would imagine the Office of Court Administration might be able to help you with those questions, but it is not governed by FOIL, and so it's sort of outside of our advisory jurisdiction. The state legislature is referenced in the Freedom of Information Law, but access to those records is, there's a much more limited scope of access to those records. I apologize that my dog is barking, sorry about that. Wish I could stop it, but at the moment there's probably not much I can do without walking away from the computer. So the state legislature access to those records is similar to how access to the 1974 version of the Freedom of Information Law was, where there's a list of the types of records you can access under FOIL, and if you don't see it on that list, you're sort of out of luck. FOIL is not going to require that the state legislature make those records available unless it's on the list. Every government agency is required to designate a records access officer. And the records access officer should be designated by name or by specific job title and business address. And when requests are accepted by email, which should be all the time, every agency is also required to provide an email address by which FOIL requests can be made. And that records access officer has the duty of coordinating the agency's response to public requests for access to records. I am going to, she must be a squirrel probably. The term records under the Freedom of Information Law means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever, including but not limited to, and then it lists a whole bunch of things, but the important thing to remember is that record is defined very broadly, and it means any information kept, held, filed, or produced by, with, or for an agency in any physical form. So it's very broad. Under the Freedom of Information Law, however, an agency is not required to create records. They're not required to answer questions. They're not required to provide information that does not exist in record form. The Freedom of Information Law governs access to existing records that the agency maintains or that are maintained for the agency. This doesn't mean that an agency is not required to make copies of records or convert records to a preferred format if possible. It just means that, you know, if for example, if someone comes, sends an email to the records access officer and asks a series of questions, for example, about how a public body or an agency came to a certain determination, the agency is not required to answer those questions. It's just about access to existing records. There are three exceptions. Excuse me, I apologize. I'm going to step away for 2 seconds. There are three exceptions to the rule that an agency is not required to create a record in response to a FOIL request. And the first is that every agency is required to create and maintain for availability to the public a record of how each member of a public body votes. You would think this would be contained in the Open Meetings Law, but oddly enough it's not. It's in the Freedom of Information Law. Anytime a public body votes, there has to be some record how each member voted. So a lot of times that information is contained in the minutes because, of course, that's the simplest way to maintain that information. If the minutes reflect that the vote was unanimous, that's sufficient because that shows how every member voted. But if there's some sort of split, like it's 3-2, for example, there has to be some record, and again, it doesn't have to be in the minutes, it just makes sense that it is in the minutes, that there has to be a record of who voted in favor and who voted against. The second exception is that every agency is required to maintain and make available to the public a list of the name, public office address, title, and salary of all its employees and officials. And every agency is required to maintain a reasonably detailed subject matter list. Many agencies, particularly local municipalities, tend to adopt the record retention and disposition schedule established by the New York State Archives as their subject matter list, and this is perfectly 100% acceptable. There's no need to reinvent the wheel if you're a municipal employee. The New York State Archives has already done this for you, so you can always just adopt the record retention and disposition schedule as your subject matter list. A little bit more on the distinction between creating a new record and preparing a copy of a record. An agency, there's a provision of FOIL that states an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. An example of this is, let's say you only have in-house, you only have paper copies of records, but you have a multi-functioning copier that can also scan those records. If you can just as easily scan those records as you would photocopy them, and the person who's making the request would like an electronic version of the records emailed to them, you should do so. An agency should do so, I should say. If you can scan them to a PDF or some other electronic format and pop it, attach it to an email, and that's how the person who's making the request wants the record, and you have the ability to do it, the agency should do that. There's another provision of FOIL that states when an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. That is not considered, the preparation or creation of a new record. An agency employee has the ability to query a database and have it run a report that contains the information being sought by the applicant. It is required to do that. If they have the ability to do it and can do it with reasonable effort, the agency is required to do it. Even if the report that's being requested is not one that's produced in the normal course of business, in the regular course of business, if the agency has the ability to extract the data with reasonable effort, it is required to do so, and it is not, under the law, considered to be the preparation or creation of a new record. The applicant who's making the Freedom of Information law has an obligation to reasonably describe the records they are seeking. And in order to determine whether the applicant has reasonably described the records sought, the first sort of common sense question is, can the records access officer look at the request and figure out what's being asked for? If not, then the person probably hasn't reasonably described the records sought. If the applicant is using terminology or phrases that the records access that make no sense to the records access officer or the appropriate staff, then it's very possible that the person who's making the request has not reasonably described the records sought. The next issue is whether the agency can locate or retrieve the records sought with reasonable effort. So it's very possible that the person who receives the FOIL request, the records access officer, knows that they may have those records somewhere, or that it's possible that they have the records somewhere, but they may not maintain their records in a manner that would allow them to locate the record with reasonable effort. And the answer to this question is likely going to be different depending on whether the records are in paper or electronic format, because it's much easier to search electronic records than it is to search paper records. A simple example of this might be if someone comes to the town clerk serving as records access officer for any particular town and asks for copies of all building permits issued in the past 5 years for houses, for blue houses. Well, that's likely not how the town maintains its records. They may not keep the color of the house may not even be referenced anywhere in the building permit application, or even if it is referenced in the building permit application, It's very possible that the town doesn't maintain its records in a way that would allow it to locate building permit applications received for blue houses, because that's just not how they're filed. They're filed by property address, by name of the property owner, things of that nature. Or if someone makes a FOIL request for copies of all building permit applications received for people who wanted to add decks to their homes. It depends. If it's all on paper, it's very likely that the agency does not maintain their records in a way that would allow them to locate the building permits that were issued for people who wanted to add decks to their homes. On the other hand, it's possible that if the agency maintains electronic records, maybe that's a field, maybe that's a data field in their database. So it's just going to be a matter of whether the agency can locate the record with reasonable effort. Will it be searching for the needle in the haystack? Would the agency have to go through hundreds or perhaps thousands of building permit applications, one by one, just to find the ones that are responsive to the request? If an agency would have to do that in order to respond, they're not required to do that. And that's based on long-standing case law going back 30 plus years now, Court of Appeals decision that basically said there's no obligation to conduct that search for the needle in the haystack. Time limits. Every agency when they receive a FOIL request, should keep in mind certain time limits that they need to comply with in order to respond. And the first is 5 business days. Within the first 5 business days of receiving a Freedom of Information Law request, the agency has to do something. It needs to either respond to the request by providing access to the records, or it could respond to the request by denying access. It could tell the applicant that the agency does not possess the records sought, or if it's a larger request or one of a number of FOIL requests that the agency is responding to, the agency may need to acknowledge the request and state that it needs more time within that first 5 business days. So if an agency needs more than 5 business days to respond to a request, what they're required to do is acknowledge the request and give an approximate date by which they plan to respond. What the law states is that generally there's sort of an assumption that the agency should be able to respond within 20 business days of acknowledging the request. So the date, under normal circumstances, that is given in the acknowledgement letter should not be any longer than 20 business days. However, the statute provides some wiggle room for circumstances where the agency is either dealing with a large number of FOIL requests, or it is dealing with the particular request that was received is voluminous or complicated and is going to require a long time to gather and review the records. If the agency requires more than 20 business days to respond to a FOIL request, it is required to provide the applicant with a date certain that is reasonable under the circumstances by which it will respond. The agency can either do this right off the bat at the time of the acknowledgement, or they can, at the time of the acknowledgement, indicate that they plan to respond within 20 business days, and then if they realize that they can't respond within 20 business days, they can, prior to the expiration of the 20 business days, they can send out one more letter stating that they need more time, and at that point they would give the date certain by which they plan to respond. In our opinion, the law does not contemplate repeated extensions. The courts don't necessarily agree with us, but based on the language of the statute, it's our feeling that that's not what the legislature intended, for an agency to be able to bump out responses month by month by month, because the applicant wants to have a concept of when they're going to get a response. If an agency keeps bumping out month by month by month, the applicant has no idea when to expect a response. On the other hand, if an agency responds by saying, listen, your request is really voluminous and complicated, and it's going to require, we're going to need 6 months to respond to that request, it may work well for the agency as well, because then the applicant may say, well, you know what, I need the information faster, and so what I'm going to do is narrow the scope of my request. Or I'm going to give you additional information that will help you speed up your search. Engaging in that sort of conversation with the applicant where the agency is being transparent about how much time it's going to take to respond to the request works well for both parties. So it's important, again, that the agency not just keep bumping it out month after month after month with no end in sight, and that they be transparent with the applicant about how long it's going to take to respond. When there is a denial of access, an applicant has 30 calendar days to appeal the denial of access. And when an agency receives an administrative appeal, the agency has 10 business days to respond to the appeal. Here at this point, I probably don't even need to include this slide anymore, but at some point, it's sort of in the more recent history of FOIL, it was amended to state that if an agency is able, it must accept requests by email. In my opinion, every agency should be able to accept requests by email at this point. An agency cannot require a requester to use its own form. An agency can require that the request be made in writing, but it cannot require that the requester use its own form. So if an agency receives a Freedom of Information Law request in writing, whether it's by email or by mail or by somebody showing in his office and dropping off a letter, whatever it may be, if they've put their request in writing, they've done their job. The agency cannot bounce your request back and say, fill out this form first. An agency cannot add additional requirements that are not authorized under the statute. Basically, it's slowing the process down by bouncing it back and requiring that the form be completed. That's not to say that there's anything wrong with having a form available. People like forms. People, go to an agency website and say, oh, look, there's an easy form that I can fill out and submit and make my request. Absolutely nothing wrong with having a form. You just, as an agency employee or as the records access officer, you just need to remember that you cannot require that they use your form. And unless there are personal privacy concerns relating to the records, an applicant for records should be permitted to remain anonymous. So for example, if someone is requesting a copy of a contract that would be available to any member of the public, and they submit a FOIL request using an anonymous email address or a pseudonym, there's nothing prohibiting for them from doing that, because the record that you would be sending back to them would be available to any member of the public, so their identity is irrelevant. They could send a request from Big Bird at 123 Sesame Street at gmail.com. It doesn't matter. If the record is public to one, it's public to all, and there's no need to require that they provide their identity. There are two types of situations that give rise to the right to file an administrative appeal. One is an express or an affirmative denial of access, and that's where the record is possessed by an agency but is withheld in whole or in part. And the second is a constructive denial of access, and that's where an agency fails to respond to the request within the time limit set forth in the statute. So for example, if someone makes a FOIL request and the agency fails to acknowledge within 5 business days, that's a constructive denial of access. If the agency acknowledges within 5 business days and says we will provide a response to you within the next 20 business days, but fails to do so, that's a constructive denial of access. And the applicant then has the right to file an administrative appeal of that constructive denial of access. And if you'll recall from the beginning when I was showing you all the website, I showed you that we have a link on our website to find model language for those types of appeals. So I'm going to go over talking about each specific ground for denial that's permissible under the statute. Could take us hours and hours. So I'm going to go over these fairly quickly, but I'm going to try to give you an idea of when these situations would come up. So on the PowerPoint, which is available on the Committee on Open Government's website, again, at the beginning when I showed you, there's a link to our training materials and recordings. This PowerPoint is there, so you'll see this information on our website. So it's A through the entire list of permissible grounds for denial is A through R, but several of them at the end relate only to vehicle and traffic law, so I highly encourage people not to worry about those too much because they come up so rarely. So on this page, you see sections A through F. On the next page, I have G, H, and I, and the remainder of those permissible statutory grounds for denial relate to vehicle and traffic law. So we'll go over some of the permissible grounds for denial that come up frequently and sort of go over the basics of when they can be applied. So the first statutory ground for denial of access is when a record is exempt by state or federal statute. Some examples is when a communication is confidential pursuant to the attorney-client pursuant to the attorney-client privilege, and the statute that makes those communications confidential is civil practice law and rules. There's a provision relating to the attorney-client privilege, and there's a provision that relates to attorney work product. So sometimes if someone makes a FOIL request for communications, for example, between the town board and the town attorney, and those communications involve requests for legal advice and the provision of legal advice, an agency is going to be permitted to withhold those records because they're exempt by state statute. If a freedom of information law request is made to a school district for a copy of a specific child's education records, those records are exempt from the freedom of information law pursuant to federal statute. It's the Family Educational Rights oh, I always forget what the P stands for, privacy probably, Act. Someone just asked, will you get a copy of the slides? I had just mentioned that the slides are available on our website. I'm not going to be sending them out individually to people, so I do ask that you not email me and ask for a copy of the slides. They're available on our website. Right at the beginning of the program, I showed you where to find them. Mental health records. If you made a FOIL request, I used to be the records access officer for the New York State Office of Mental Health. If someone came to me and made a FOIL request for an individual's mental hygiene record, even if they were making a FOIL request for their own mental hygiene records, their own psychiatric records, FOIL was not the appropriate mechanism. They needed to make a request for those records pursuant to the provisions of mental hygiene law. So that's another example where the records are exempt by statute. Autopsy records are exempt under county law. County-operated 911 records, including recordings and transcripts of those calls, are exempt from FOIL under New York State county law. Social security numbers are exempt from disclosure pursuant to Public Officers Law, Section 96A. So those are just some examples. There's several more. So you just want to be familiar. If you do work for a government agency, you want to make sure you're familiar with the confidentiality statutes that govern the records that your agency maintains. Another ground for denial is unwarranted invasion of personal privacy. And a record or a portion of a record can be withheld if disclosure would constitute an unwarranted invasion of personal privacy. Some examples of that would be employment applications of persons that were not hired. So say there was a job posting and 10 people applied for a particular position and only one of them was hired. The names and identifying details of the individuals who applied but were not hired could be withheld. Generally, this means that the applications or resumes could likely be withheld in their entirety. The courts have held that if you can redact the applications or resumes sufficiently to protect the identity of the applicants, you should do so. But I will note that there are situations where that's not possible. If someone makes a Freedom of Information Law request, for example, if they wanted to see, if I applied for a position, I'm the only person who had served as the Assistant Director of the Committee on Open Government for the past 6 years, and prior to that, 10 years with the Office of Mental Health in their counsel's office. So my resume is so specific to me, there likely isn't any way to redact it sufficiently to protect my identity. There might be other situations where it's possible, but in many cases it's not. If your agency maintains medical information about your employees or other members of the public, even if that information is not maintained because you're a healthcare provider and that information is confidential under HIPAA, again, it might be just because you have medical information in your employees' files or for some other reason relating to a member of the public. Medical information, if disclosed, could constitute an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld on this ground. Lists of names and addresses of natural persons if used for solicitation or fundraising purposes. So for example, if someone makes a FOIL request to the town clerk for a copy of all individuals to whom dog licenses have been issued in the past 10 years, the names and addresses of people to whom dog licenses have been issued in the past 10 years, the person who, the records access officer can require that the individual making the request certify that they will not use that information for solicitation or fundraising purposes. If the person pulls up outside their office in a mobile dog grooming van and the town clerk looks out the window and says, I see that you pulled up to the window in a mobile dog grooming van, the likelihood is the town clerk could just simply deny on the grounds that is their belief that the information would be used for solicitation or fundraising purposes based on the identity of the individual. Another example is mugshots. Law enforcement agencies are permitted to withhold mugshots on the ground that disclosure would constitute an unwarranted invasion of personal privacy, and that's a fairly recent amendment to the law within the past 5 years or so. Another ground for denial of access is law enforcement records. And in order for a record to be denied under the law enforcement provision, it's a two-part test. Records must meet both parts of the test in order to be withheld. And one is the record must be compiled for law enforcement purposes. And the phrase compiled for law enforcement purposes does not contain a requirement that the record be compiled at a specific time. And to explain this, what I mean is if at the point the FOIL request is made, the records have been put together for a law enforcement purpose, then they've been compiled for a law enforcement purpose, even if the original purpose of those records was not for law enforcement. This came up a couple of years back in 2016, 2017, relating to an employee of the executive chamber, and a request was made to the New York State Executive Chamber, the governor's office, for copies of this individual's timesheets. Now, of course, in the normal course of business, timesheets are not compiled for law enforcement purposes. However, at the point that the request was made, those timesheets had been gathered and been put together and turned over to the Department of Justice. So at the point that the request was made, they had been compiled for law enforcement purposes. So therefore, it met the first part of that test. And this first part of the test does not just apply to criminal law enforcement, it can also apply to civil law enforcement. So if you have a government agency that has civil law enforcement authority, and it is compiling records as part of an investigation, it can assert this ground for denial as well, if appropriate. The second element, the second part of the test, is that disclosure of the records would need to cause one of the harms envisioned by the statute. It would need to interfere with a law enforcement investigation or judicial proceeding. It would need to deprive a person of the right to a fair trial or impartial adjudication. It would need to identify a confidential source or disclose confidential information relating to a criminal investigation, or it would need to reveal non-routine criminal investigative techniques, which essentially would give potential criminals the combination to the safe, so to speak. At this point, I'm going to take a little bit of a break from the PowerPoint and pull up some recent legislation that was passed. And the reason why I haven't incorporated the new legislation into my PowerPoint is because the governor, at the time that she signed, signed the legislation, she also issued an approval memo. And the approval memo essentially said, we like parts of this bill that we're signing, but we don't like all of it. And we want the legislature to go back to the drawing board and make some changes. So I just want to very quickly go over what the law states. It was signed, remembering the signed signature date. I apologize, I forget when those. It was fairly recent. Chapter 808 of the laws of 2021. So it was signed at the end, it's right in front of my face, December 29th of 2021. It was when it was signed by the governor. And there's some provisions of Chapter 808 that relate to an agency's responsibilities under FOIL, generally, and also specifically relating to law enforcement records. So this paragraph that I have pulled up right now that you see in blue talks about what the legislature intended agencies to have to do when they wanted to deny access to a record based on the ground that disclosure would interfere with a judicial proceeding. What the legislature passed was language basically stating that if an agency, let's say a district attorney's office or a police department, wanted to deny access to records on the ground that disclosure would interfere with a judicial proceeding, they had to go through this entire review process involving the court system. And I'm not going to go into too much detail because when the governor signed the bill, she said, I don't think this is good. I don't think this is going to work. So it would require the judge to notify the person requesting the record that they have the right to have a hearing, an opportunity to be heard. It would involve the court system. It was going to, in my opinion, require quite a bit of work on the, be maybe a burden on the judicial system. I'm not really sure how it would have worked because the law doesn't go into a lot of detail, or the bill that was passed doesn't go into a lot of detail. So I'm going to flip over to this approval memo, and I'll show you that what the governor said was, the bill amends the public officers law to require an agency that is considering asserting a law enforcement exemption under FOIL on the grounds that it would interfere with a judicial proceeding receive permission from the presiding judge in the judicial proceeding to assert this exemption. And then the governor goes on to say, in order to ensure that there are no unnecessary delays or confusion when it comes to the public's access to public records, I've secured an agreement with the legislature to make amendments to this bill. These amendments include removing the requirement of an agency to interrupt an ongoing judicial proceeding to seek permission from the presiding judge before asserting the law enforcement exemption on that ground that it would interfere with the judicial proceeding. So essentially, I think what the governor is saying, I don't really think this is going to work, but we haven't seen the new amended language yet. So we're a little bit in limbo right now. And until that gets clarified, I don't want to spend a whole lot of time talking about those obligations. All right, so I'm going to go back to our PowerPoint. Another ground for denial that is asserted fairly frequently by government agencies is the intra-agency and interagency material exemption. And the goal of this permissible ground for denial is that it is intended to protect the deliberative process. So interagency means all within a single agency. So for example, you have email communications between and among town board members, the supervisor, the town clerk, the town attorney, all within a single agency. That's intra-agency. Interagency material would be, for example, if the town clerk emails me, Kristen O'Neill, at the Committee on Open Government and asks my opinion and I respond by providing my opinion. That is interagency material because it's communications between or among two or more government agencies. So if a request is made for all email communications, for example, between and among town board members relating to a particular issue, to a large extent, it's very likely that those are going to be permitted to be withheld under the interagency material exception. However, they may not be able to be withheld in their entirety because the person who is reviewing those records to determine rights of access is going to need to determine whether those communications contain any statistical or factual information, any instructions to staff that affect the public, any final agency policies or determinations, or whether the records constitute external audits, such as external audits conducted by the Office of the State Comptroller. Any of those exceptions to the exception, so to speak, must be disclosed unless another ground for denial can be asserted. So statistical or factual information needs to be disclosed, even if it's contained within interagency material. Instructions to staff that affect the public needs to be disclosed, even if it's contained within interagency material. And again, any final agency policy or determination, even if it's, again, only maintained internally within the government agency, still would need to be disclosed, absent other grounds for denial that can be asserted. I'm not sure if I addressed this, so I want to make sure I do and not forget. Unless there's another unless there's a federal or state statute that prohibits disclosure or that separately governs access to a particular type of record, the ability to withhold records under any of the other grounds for denial is permissive. So for example, an agency is permitted to withhold records when disclosure would constitute an unwarranted invasion of personal privacy, but it's not required to. Same goes for law enforcement records. The same goes for interagency material. Agencies are permitted to withhold those records, but are not required to withhold those records. So that's just something to keep in mind. The exception, though, of course, is if there's a separate statute that governs disclosure. Again, when someone made a FOIL request to me as the records access officer at OMH for someone's psychiatric records, that was not within my discretion to decide to disclose. The mental hygiene law specifically prohibited disclosure, and I had to comply with that state statute. There's also a certification requirement that comes up when an agency states that it does not possess the records sought or that they cannot locate the records sought. Section 89(3)(a) of FOIL states in part that upon payment of or offer to pay the fee prescribed, the entity or the agency shall provide a copy of the record and certify to the correctness of the copy. So the first part of this certification has to do with when someone makes a FOIA request for a record, the agency provides the record, maybe the person who's receiving the record and says, I wonder if the agency fiddled with this or messed with it before they sent it to me. the person who's making the request has the right to certify that the copy that they received is a true and accurate copy of the record that is maintained by the agency. So that's one part of this language. An applicant can request a certification as to the correctness of the copy. That doesn't mean that the actual content of the record is correct. There may be errors or mistake in the original document, but the copy that was provided to the applicant has to accurately reflect the copy that is maintained, the original copy that is maintained by the government agency. The second circumstance that allows an individual to request a certification is when the agency says, we don't have what you're looking for, or we can't find what you're looking for after a diligent search. An applicant can request a certification to that effect. So the agency would certify that it does not have possession of the record, or that the record cannot be found after a diligent search. And there's no specific form that this certification needs to be in. I just recommend when government employees ask me, I just recommend that they use the words, I certify, that the certification includes a brief description of the records that are at issue, and then they just model the language of the statute. Either they state that they do not possess those records, or that the record cannot be found after a diligent search. The law doesn't state who must provide the certification. Many times it's the records access officer, but sometimes if the records access officer has asked, for example, somebody in the buildings department to conduct the search, the records access officer can ask someone from the buildings department to provide the certification, since they were the one that conducted the search. It's whoever the agency feels is in the best position to know whether a diligent search was conducted. That's just a repeat of the language we just discussed. So a little bit more about the right to appeal. When an agency denies access to a record or any portion of a record, and this means that even if a record is just redacted in small part, that's a denial of access that gives right to the rise to an appeal. And the applicant has 30 calendar days to appeal. When there's a denial of access, the agency has an obligation to put the denial in writing with an explanation of the reason for the denial. The recently passed statute that we just discussed a few minutes ago, Chapter 808, included additional requirements for how detailed this initial denial of access had to be. But until we see the amended language and the amended legislation, we want to hold off on providing guidance because it's not quite clear what the legislature intended with this. Basically what they said was that the records access officer had to provide a particularized explanation for the denial, which is generally the standard that the agency has when they go to an Article 78 proceeding. So it seems like a little much at that initial level, but I'm not quite sure what the legislature intended. And until we see the amended language, we're going to hold off on providing detailed guidance on that amendment. So at this point, what the records access officer is required to do is to provide a reason for the denial in writing and to give the applicant instructions for how to file an appeal. The applicant has 30 calendar days to appeal the denial, and the FOIL appeals officer is the head or governing body of the agency, or sometimes or often the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same as the records access officer. So for example, if the town clerk serves as the records access officer, the town clerk cannot also serve as the FOIL appeals officer. Within 10 business days of receipt of an appeal, the FOIL appeals officer must either provide records sought or fully explain the reason for further denial. And sometimes it's going to be a combination of those two situations. Perhaps the FOIL appeals officer agrees with part of the initial determination, but not all of it. So the appeal determination should reflect whether any records or additional records are being disclosed, and if they are all going to be withheld, or some of the records are still going to continue to be withheld. There needs to be a full explanation for why they're going to continue to be withheld. It's important to note that the law does not contemplate a remand back to the Records Access Officer. It is the responsibility of the appeals officer to review the record and determine rights of access once they receive an appeal. All right, fees. Fees drive everyone crazy for some reason. So we'll go over this for a little bit of time. Under the Freedom of Information Law, there are two fee structures, and these two fee structures cannot be combined. The first fee structure is for photocopies up to 9 by 14 inches. When an applicant requests photocopies of a record maintained by an agency, the agency is only permitted to charge 25 cents per photocopy if the record is up to 9 by 14 inches. That's it. End of story. That is all the agency is permitted to charge. The agency is not permitted to charge for search time or review time or the time it takes to make the photocopies. The agency is only permitted to charge 25 cents per photocopy. That's it. Done. So that's the first fee structure. The second fee structure is if it's a record larger than 9 by 14 inches or if it's a record in some other form other than photocopies. And if that's the case, what the law states is that the agency can charge the actual cost of reproduction. And then the law goes on to state what the agency is permitted to take into consideration when determining the actual cost of reproduction. One of the factors that is allowed to be considered is if it will take at least 2 hours for an employee to prepare a copy of the record, the agency is permitted to charge the hourly salary of the lowest paid employee capable of performing the task. But again, only multiplied by the number of hours it takes for the employee to prepare the copy, but only if it takes at least 2 hours. So let's use scanning as an example. Let's say an agency, in response to a FOIL request, an agency needs to scan records. If it would take only a half hour to scan the records, then there will be no fee that is permitted to be charged because it takes less than 2 hours and you're preparing a copy of a record in a format other than photocopies. So essentially you would scan those records, attach it to an email, send it off, no fee charged. If it does take at least 2 hours to scan those records, then let's say it takes 3 hours and you have someone who is paid $15 an hour, you can charge the requester $45 for the preparation of the copy of the record, for the scanning the record, because it took 3 hours at $15 per hour to make the copy of the record. And if you need to place the record on an electronic storage device because it's too large to send via email, you can get reimbursed for the cost of the electronic storage device, like a CD or a thumb drive. If you don't have the technological capability of making the copies in-house, let's say blueprints or maps or audio or video, you can be reimbursed for the actual cost of having the copy made by a third-party vendor. But again, an agency cannot charge for search or review time. It cannot charge for the time it takes to locate the records. It cannot charge for the time it takes for an agency employee to review the records to determine rights of access. Right at the beginning of this program, I mentioned that the two fee structures can be combined. So often, I see agencies that want to charge 25 cents per photocopy and an hourly rate for the time it took an employee to review the records to determine rights of access, or 25 cents per photocopy and an hourly rate for the time it took an employee to locate the records that were being sought. You cannot do that. The only thing that the law allows is either 25 cents per photocopy or the actual cost of making the copy. If you have questions about this, you're always welcome to call our office. Enforcement of the Freedom of Information Law is via a CPLR Article 78 proceeding, a Civil Practice Law and Rules Article 78 proceeding. The Committee on Open Government does not have enforcement authority. We do not have the authority to investigate complaints. We do not have the authority to compel an agency or a public body to take certain actions. We have the authority to provide advice and legal opinions regarding the open government statutes. So if someone wants to challenge a determination made by an agency with regard to a FOIL appeal, their remedy is to bring a CPLR Article 78 proceeding. If the petitioner is successful, substantially prevails, the courts can award attorney's fees and other reasonable litigation costs. Attorney's fees are mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. Attorney's fees are discretionary on the part of the judge when the requester has substantially prevailed and when the agency failed to respond to a request or appeal within the statutory time period. So that is the enforcement mechanism under the Freedom of Information Law. Always remember that anyone is welcome to call or email our office with questions about the Freedom of Information Law and the Open Meetings Law, whether you're a government employee, member of the public, media representatives. There's our phone number. That's our generic email address. I do want to go back. I know somebody emailed me, I think yesterday, with a question about fees. So in my mind, as it's fairly recent in terms of our presentation, I'll go back to that. Someone asked the question of whether, if you receive multiple FOIL requests within a short period of time, let's use an example of over the course of 3 days, you receive 20 FOIL requests from the same individual, and each separate FOIL request that you receive requests a separate document. I think the question is, if it's going to take us more than 2 hours to make copies, and let's assume that they want them in the electronic format, not photocopies, because again, if they want photocopies, it's 25 cents per photocopy, and that's the only fee. But let's assume they want them scanned. Or let's assume that they want data extracted from a database. In our opinion, if you receive multiple requests for records within a short period of time, let's say within a week, from a single individual, and combined, it would take 2 or more hours to prepare copies of all of the records that were requested within those multiple requests, you can combine. I don't think an applicant should be able to avoid getting a fee charged by submitting 20 separate FOIL requests as opposed to a single FOIL request with 20 separate records referenced in the request. You can combine the 20 FOIL requests for fee purposes. So that was, I know, one question that somebody asked me earlier this week. So what I'm going to do at this point is I'm going to turn off sharing so that I can pull up, want to be able to pull up the chat function and sort of peek through the chats and answer any questions that may have come up through the chats. A lot of people helping me out with the original screen thing, so. Someone asked, relating to timelines, if an agency acknowledges it within 5 days, do they have another 20 days to respond? I mean, I think we did go over this in quite a bit of detail regarding the time limits. If an agency acknowledges a request within 5 business days, then the rest of the time limits start ticking in. They generally have 20 business days from the date of acknowledgement to respond. If they need more than 20 business days, they're supposed to give a reason for the delay and a date certain by which they plan to respond that is reasonable under the circumstances. The slides are available on our website. Someone asked a question about vaccination status of public employees or percentage of public employees vaccinated. In my opinion, probably the vaccination status of public employees, disclosure of that information could be determined to be an unwarranted invasion of personal privacy. On the other hand, percentage of public employees vaccinated, if you can disclose the data without identifying, without providing personal information about specific employees, then I think data should be disclosed. Another question is about interagency. What about a legislature giving instructions to a committee chair that affects the public? I'm assuming we're talking like not at the state level, because the state legislature is not an agency, is just defined by the Freedom of Information Law, so is not covered under the interagency exemption. But let's say we're talking about a county legislature giving instructions to a committee chair. Again, I don't know what the instructions are, but the exemption is instructions to staff that affect the public. If the instructions to the committee chair, if the committee chair is required to comply with something and the legislature has the authority to direct that committee chair, then I would, in my opinion, that those instructions affect the public, then that would need to be disclosed. Question, with regard to delays in sending information on FOIL requests, should an agency be transparent about why there is the delay, not just how long the delay will be? There is an obligation under FOIL to provide an explanation for the delay. The law requires that if you require more than 20 business days, you must give a reason for the delay. Question is, are communications between state agency and vendors considered interagency, or are they protected by any other rules? In general, the answer is no. Vendors are not agencies. However, there are circumstances where the courts have determined that the vendors are acting as a consultant for a government agency. And if they are acting as a consultant for the government agency, then those communications would be considered intra-agency. Someone asked about, is there anything in the law that allows for extensions of the time it takes to respond to an appeal? The answer is no. The law does not allow, does not contemplate an extension beyond 10 business days for responding to a FOIL appeal. If there's complications, what I encourage agencies to do is to reach out to the application and explain the reason for the delay and cross your fingers and hope for the best. Someone asked a question about the open meetings law, which we're not talking about today. So if you have questions about the open meetings law, I ask that you follow up with us directly about that, because that's not the top subject of today's program. Someone asked if the FOIL law changes between denial of access and submission of appeal, which version applies to the appeal? I don't understand the question, I think. But sometimes when the appeal officer reviews the initial determination, they may have a different reason for denying access, and they're free to do that. Oftentimes, again, the FOIL appeals officer is digging in a little bit deeper and is going to provide a full explanation. So there may be a reason asserted by the FOIL appeals officer that was not asserted by the by the records access officer. So that's I guess I'm not sure that I'm answering the question, but the person can follow up with us directly if they have questions. An applicant contacts an agency wanting to see a record, but the request was an informally written email that made no mentioned that the communication was a formal FOIL request. Anytime a request for records is submitted to a records access officer, you should treat it as a FOIL request. If an employee receives a request for records and it is not their responsibility to respond to FOIL requests, I think there's a couple of options. One, maybe it's a record that that employee makes available in the regular course of business. Let's say, someone comes to the building department and requests a copy of permits. Some towns and cities and villages just allow their building departments to provide that information without the applicant submitting a FOIL request. So if the employee has been given authority to disclose those records, then they continue to have that authority. However, if an individual, if an applicant just submits a request for records to a random government employee that has no connection to FOIL for records that that employee has no authority to disclose, what the employee should do is redirect them. The employee should redirect them and tell them how to make a FOIL request. Someone said to me, legislature has made clear the agency has right to charge a fee. Scanning is simply newer tech for photocopying. It's not. That's not what photocopying is. Photocopying involves paper and ink. So it's a different format. It's a format other than photocopying. Question is, how can the agency not charge a fee for electronically stored docs? If you already maintain the records in an electronic format, then there's no need to make a copy because it already exists in the format that you're providing to the applicant. So I don't really see where would the cost be in making the copy. It already exists in the format that you're going to be providing to the applicant. If you're scanning, again, it depends on how long it takes to scan the records. Scanning is not just a newer technology for photocopying. It is a separate process. If a third party requests client information, can this be treated like a client request for records and a FOIL request? Again, this is a situation where I don't really understand the question. If an agency receives a request for, let's say they receive a request from an attorney who states that they represent a particular individual, and the records that are being requested contain information that the agency would, under the normal course of business, deny on the ground that disclosure would constitute an unwarranted invasion of personal privacy. But you would disclose those records to the subject of the records because it's their privacy and they have the right to waive their own privacy. If it's a third party making a request on behalf of the subject of the records, I would just ensure that you have documentation reflecting that they represent the subject of the records, is what I would do. Someone says, can a requester remain anonymous when requesting an employee's personnel file? If the record, what you do is when you receive an anonymous request, you respond to that request in the same way that you would respond to a request from any third party that is not a subject of the records. So for example, if I want a copy of my own personnel file, I'm not going to make a FOIL request for that, most likely. I'm going to go to Human Resources and have a conversation with them. But if I want to make a Freedom of Information, law request for another state employee's personnel file, it doesn't matter who I am. I'm only going to get what any member of the public has the right to. So I should be able to make that request anonymously. And then the agency that maintains the record will only disclose what they would normally disclose to any uninvolved third party. Someone asks if the actual record being sought doesn't exist, we have to provide the information. I mentioned in the beginning, under the Freedom of Information Law governs access to existing records. There's no obligation to create a new record to respond to a FOIL request, and there's no obligation to answer questions. Someone asked if there's a reasonable time for a request of records. Is 10 years worth of records too long? Can it be denied? There's no ground for denying FOIL requests based on volume. Whether it's reasonable or not is going to be subjective. But an agency cannot deny a request based on the simple fact that it's 10 years worth of records. You may take a really long time for you to get those 10 years of records, and that's why you may want to consider narrowing the scope of your request, because, for example, if you request only 1 year of records, it's going to take a lot less time to get those records than if you're requesting 10 years worth of records. But no, an agency can't deny a request simply on the fact that it's a lot of records. Someone writes that requests for interagency email content can be labor intensive. Can you combine a discussion regarding the review of these emails that may take 8 hours for legal review? Can you charge over the 2 hour? No. Someone's asking, can you charge for the time it takes to review for legal review? No, we talked about this. You cannot charge for the time it takes to review the record to determine rights of access. You cannot charge for legal review. That is not part of making a copy of the record. Someone asked if there are any types of officers for FOIL other than FOIL Appeals Officer and Records Access Officer. Those are the only two individuals or positions identified in law and regulation, but that doesn't mean that there aren't numerous other people that don't get involved in the FOIL process. You can have more than one FOIL Records Access Officer. You can have more than one FOIL Appeals Officer. You can have an Assistant Records Access Officer. But in addition, really every agency, every employee of a government agency is obligated to assist the Records Access Officer and FOIL Appeals Officer when requested for assistance. So you can have, I mean, large agencies are going to have often more than one person handling FOIL requests or assisting with FOIL requests. And you can call it whatever you want, as long as you have at least one individual dedicated as Records Access Officer and FOIL Appeals Officer. Someone asks about, can financial records such as credit card statements be denied? The answer is probably no. If you have, if a government employee is issued a government-issued credit card, the likelihood is the actual credit card numbers can be redacted to ensure financial security. The content of the credit card statement should be disclosed to reflect what the individual is purchasing with that credit card statement. Someone just asked a question that I just went over about bundling FOIL requests bundling FOIL requests when they make FOIL requests. Multiple FOIL requests within a short time period. Someone asked that question, but I just responded to that recently. Someone asked, can I speak to making a request for documents provided as machine readable rather than graphic images? Essentially, if an agency has the ability to provide the record in the format requested, it should, is the short answer. This comes up oftentimes with, let's say someone wants the record in its original Excel file as opposed to a PDF. If someone wants it in the original editable Excel file version, the agency must provide it in the editable Excel version. If you have the ability, if an agency has the ability to provide a record as machine readable, in my opinion, it should. Someone asked whether you can redact agency email addresses from email FOIL requests. My short answer is probably not. a FOIL, a public employee's government-issued email address. There is no privacy interest generally with that. There may be small exceptions that I can't think of off the top of my head, but in general, no. A public employee's email address should be disclosed. One more question. If records are requested to be provided in another language, is there any obligation to do so? No, not if they don't already exist in another language. If you don't possess, like if, for example, if you only have a record that's in English and someone is saying, well, I want it in Spanish, and you don't possess it in Spanish, you're not obligated to have it translated into Spanish for that individual. You can provide it in English, and then they're free to do with it as they want. So that is the last question that popped up. So that is where we're going to end for the day. Again, I'm just going to remind everybody that the recording of this program and the training materials are going to be made available on my website. I'm going to show you one more time. I'm going to pull up, I closed it out, but I'm going to show you one more time. Just a second. All right, so if you go to our home page and you scroll down to this blue-green area, you're going to see this box right here that says View Training Materials and Recordings. Click on this box. This green box is where you will be brought to our YouTube page that has several of our past training recordings, and you'll hear our PDF copies of our FOIL and Open Meetings Law training materials. So I will not be responding to individual requests for copies of the materials or the recordings, but just so you know, it's there. It's available for anyone who needs it. Thank you all for joining me today. I hope you found it useful, and stay warm and have a good weekend. Thank you.